Thank you, Chair, and thank you to all the witnesses for being here this evening. I was about to say today, but really is this evening. I'd like to start with Mr. Lupret, if I could, please. Mr. Lupret, you were very, and I hope I'm saying your name close. All right, I got a thumbs up, so I'm close. You were very passionate in your opening remarks, and I was listening quite intently, and you mentioned the very beginning of it about systemic infiltration, and you mentioned the words treasonous behavior. Could you expand on where all you think this systemic infiltration is?
Look, it's not what I think in terms of systemic infiltration. We have plenty of evidence at the municipal level in terms of infiltration. We have ample evidence in terms of research security within our universities. We have evidence at the provincial level of government. And we have evidence, including charges laid within private and public sector institutions in this country, including, of course, the government just this past week, forcing two entities in Vancouver engaged effectively what it appears to be the illicit transfer of dual-use anti-drone technology to a hostile actor. So I don't know. I can send you a long list, but the public record on this is extensive.
Well, I appreciate that. That's a good start, and that's a little disheartening to hear, but at least we're doing something to try and correct it a little bit now. I'd like to stick with you, sir, if I could, because we've heard different perspectives on the in favor and opposed to Bill C-70's country agnostic approach to the foreign registry list. I think the beginning you mentioned you definitely see a benefit to listing countries. Expand on that, why you see that being a benefit. And you mentioned persons too.
Yeah, I figure this is probably going to be one of the more critical decisions and one of the more controversial decisions. And I can see both sides, including Director Fadden's sort of case for not. I think giving the minister the option. So look, much of what this legislation will ultimately do, rather than us sort of prosecuting people, is about drawing red lines. It's establishing clearly what sort of behavior is and is not acceptable in this country. This is what much of criminal code, for instance, also does, right? Just laying out the rules of the road. And the problem that, for instance, universities have when it came to research security, where the government made a similar choice, where it listed only public sector entities, but not private sector entities, all of whom have Communist Party structures within them that pose the exact same threat that public sector entities engaged in intelligence and defense do, is that for universities, private sector actors, it doesn't provide a reference point based on which they can then engage in higher scrutiny. And so without government providing that reference point, it'll become relatively easy to accuse universities of randomly, for instance, scapegoating or whatnot. And so I think more direction from government is required for those players that do not have the classified access that federal government entities do, including on the research security side, for instance, where I chair the Ontario Research Fund Advisory Board, and where we know there's significant challenges around what is being funded.
I'd like to move to Mr. Neiman. Mr. Neiman, in a letter to the previous Minister of Public Safety, the Business Council of Canada stated that you wanted to see, and I'll quote this, amendments to the Canadian Security Intelligence Service Act to allow CSIS to proactively share threat intelligence with employers where it is in the public interest and subject to all necessary safeguards and oversights. Can you speak to this new information sharing powers in C-70 and if that's meeting your requirements?
Thank you for the question, Chair. So as I mentioned in my opening remarks, CSIS is presently prohibited by its governing statute from sharing all but the most generalized information with the business community. And this is because, for lack of a better word, the federal government is the CSIS's exclusive client. Therefore, the private sector can't get access to information, academic institutions can't get access to information, nor municipalities or Indigenous governments. The only exception to this general rule is once a national security threat materializes into an imminent national security event. And at that point, CSIS, if it can satisfy some very stringent legal requirements, it can use its threat reduction mandate to alert a specific company about a specific threat. This means of sharing information, it's very much a legislative workaround. These threat reduction powers were not designed for information sharing, and so this process is deeply flawed. The main reason it's flawed is because, as I mentioned, there's a very strict legal requirement that must be met before information can be shared. That means that these powers are rarely used. Second of all, the regime is reactive in nature. A threat information can only be disclosed after a material and an immediate threat has emerged. At that point, that information provides very little utility for a business, as their options to mediate or to mitigate the threat is very few. Moreover, that, as I mentioned, that the disclosure can only be made to a specific business that has been targeted. So if the goal is to strengthen the overall resiliency of the Canadian economy, well, that the current set of tools are inadequate. And that's why the Business Council has been very supportive of the adoption of Clause 34.3, which allows CSIS to proactively share threat intelligence with a broader set of stakeholders, including the business community. You mentioned in there that the Business Council, as a part of advocating for these changes, we've been very clear from the start that any new amendments must be reflective of the values that we share in our society, including protection of individuals' rights and freedoms. And so we're very pleased to see, and I can get into this more maybe in another question, but there's a number of checks and balances to protect individuals' privacy, corporations' privacy, as well as there's accountability mechanisms there as well. For instance, if there's a disclosure of personal information or corporate information that is otherwise prohibited, that information needs to be shared with NCERA. And there also needs to be ministerial authority granted, and the minister in that case must be of the view that the disclosure is essential in the public interest, and that the benefit of the disclosure to Canada's national security clearly outweighs the privacy implications.
Thank you, Mr. Shipley. We go now to Mr. McDonald for 6 minutes, please.
Being here, Mr. Neiman, I'm going to continue on with following up on Mr. Shipley. It's Business Council of Canada. About 2 weeks ago, I had in the Insurance Bureau of Canada and discussed the increasing risk that small and medium enterprises are facing, possibly through cyber attacks, which can lead to foreign interference based on whatever content that they're in possession of. And it was interesting because they were asking us, relevant to how do they deal with it? So how are companies dealing with something like this now? Are they buying insurance policies on cyber attacks, and which will lead likely to foreign interference if, for example, that they hold certain information that could be very essential to them, to an individual or a community group or something?
Mr. Chair, thank you for the question. The Business Council, we represent approximately 170 of Canada's largest, most successful businesses, so I can't speak to the specifics of the challenges facing small and medium-sized businesses. But what I can say is that small and medium-sized businesses, they're very much a part of the supply chains of large businesses, and large businesses are quite concerned about their security posture of small businesses, because that can often be an indirect route to attack large businesses. And so there needs to be much more done in this space in terms of government support, and Bill C-26 is one way to help in that regard. The private sector itself is also willing to step up and do more. For instance, our members are very much committed to working with their supply chains to build up their baseline resiliency, including through education, capacity building, and relationship brokering, including working jointly with Canada's security and intelligence community, such as agencies like CSIS, CSE, and the RCMP.
And this committee just did a review of Bill C-26, and during that testimony we heard that there was about 5.2 million cyber attacks in 4 months in 2023 from September to December, if I think of them correct, 62% of which were targeted critical infrastructure. And in our testimony of our last meeting, Michelle Junot stated that 86% of our national infrastructure is either owned or operated by the private sector. So it's going to become a very serious issue, or it already is a very serious issue. We may not even be aware of what's transpiring underneath. But what's the best way to go about this, to delivering that message and ensuring that there's safeguards in place within this bill? Or you talked a little bit about, you had 40 items that you guys did a report on. Can you maybe talk a little bit about, give us a couple of examples on that and relevance?
So the Business Council did put out a recent report last September setting out pretty comprehensive set of reforms that we believe the government of Canada should adopt to address the most glaring gaps in Canada's economic security posture. We were very happy to see that a number of them were incorporated in this bill, particularly the Clause 34, allowing for increased information sharing. And as I mentioned at the beginning of my remarks, that we've also supported the Foreign Influence Transparency Registry, as well as the new sabotage offenses as it relates to the protection of essential infrastructure. At the same time, I mentioned in my opening remarks that we think that this bill should move forward on an expedited basis, and so we wouldn't want to make significant changes to the bill that would slow down that process. However, we would hope that the government would try to bring in some of the additional changes that we suggested. But you mentioned critical infrastructure, and I just want to provide a short commentary on that. The Business Council is very supportive of the amendments to the sabotage provisions. We note that the current provisions in the criminal code date from 1951, and they have not been updated since then. Obviously, the threat environment has changed drastically since then. We see more and more that our adversaries have an increased intent and willingness to target and undermine our critical infrastructure. That those are the systems that allow Canadians to heat and power their homes, communicate with their loved ones across this vast nation, as well as to get their goods to and from international markets. And the disruption to those systems would be absolutely devastating to Canadian society. I don't think I exaggerate much when I say that a substantial disruption to our essential infrastructure could put millions of Canadians' lives, their security and prosperity at risk. So we think that the amendments are a good step forward. And we're also very happy to see that the government has included some safeguards in there, including to make exceptions for work stoppages related to labor disputes, as well as exceptions for individuals that are legitimately engaged in advocacy, dissent, and protest, as well as the requirement for before proceeding to be brought for the Attorney General to provide consent. We think that those protections in there provides the right balance between protecting Canada's economic and national security, while at the same time making sure that these provisions are respectful to individual Canadians' rights and freedoms.
Do we have much time left, Mr. Chair?
28 seconds.
20 seconds?
28.
28. Mr. Rapeau, if I didn't ask you a question, our good friend Mr. Desiree would be upset with me when I get returned to Prince Edward Island. So I'm going to ask you quickly. You talked a little bit about, and you didn't use this word, but contextualization of maybe the agnostic list. You were somewhat against that in your preamble. And can you quickly just give me before the chair cuts us off, your main reason for that?
I think entities need a clear signal of the so if you're a university, you're a private sector company. So to be fair, you now need to, and Australia ran into this problem where all actors, foreign actors, need to be treated equally. So if you're a foreign visitor to, for instance, a university from Germany, or you're a foreign visitor from, I don't know, some hostile state, the university cannot treat the risk assessment differently. So it means the very scarce resources you have, you cannot deploy in a targeted fashion. So just giving the minister the option. The other advantage is it allows the government to negotiate, because if it gets indirect threats from a hostile state actor, the government can now sort of indirectly signal that, well, if you're going to treat us like that, we might end up listing your particular country. So maybe two can play at this game.
Thank you. C'est maintenant Monsieur Villemure.
Mr. Villemure, you now have the floor. 6 minutes. Thank you very much, Chair, and thank you to all our witnesses, Mr. Lehman, Mr. Luprecht, and Ms. Rowe. So I'd like to talk about something you said. You said earlier on that it's too restrictive, or there's one word too many, too few words. I'd like you to be able to expand a little bit. Well, if I take 52.4, for example, on the consent of the Attorney General, there cannot be a proceeding for an offence under subsection 52.1, 52.1, or 52.2 without the Attorney General's consent. So the Attorney General is defined for the federal government, but what about the provinces? If the government of Ottawa wants to have discretion, then it has to say Attorney General of Canada. That would allow the federal government to have this kind of discretion over some sections in the criminal code. So it would also work better internationally. There's also an exception under subsection 5. That is to say that protests are, if something happens during a protest or advocacy, but there's no intention to cause any of the harms, well, that's very broad. And the same problem occurs. I haven't seen this kind of section in New Zealand. I only saw it in this bill. So there would be problems in this being too broad a section. Well, what about amendments to the CSIS Act? On protection of information, you mean, or rather security of information? Because I'm not familiar with all the terms that have been used, but there are some sections that are in the criminal code, and so I restricted myself to those sections. So there's 20.4, where there is mention of influencing a political process directed by a foreign entity. It's a very general section. Yes, the foreign entity is defined. However, I can see how there would be examples. I'm sure the committee had certain ideas in mind when it proposed these amendments. However, when you word it like this, when you talk about groups of influence, well, that could cover many groups. And I would say, once again, it's too broad, especially when you're speaking about criminal offenses. So perhaps it actually could be challenged. Mr. Lebrecht, you were very passionate, and basically it boiled down to this is the minimum. You said many things, but if you were going to have a list of priorities of what was lacking, what would you say those are? Well, I would say generally that at the federal level, there's a problem with information sharings in an efficient way, effective way, and in a timely way with those stakeholders involved. And we've seen this raised before in recent reports of committees. For example, those dealing with accountability.
FINTRAC has trouble sharing the right information. We know this from CSIS. We know we have it within agencies and between agencies. And so I think the way the bill enables the ability to share information within government, with external stakeholders, and we have some very good models. The Canadian Cyber Threat Exchange, for instance, the Canadian Center for Cybersecurity, where I think there's probably significant synergies with CSIS in terms of sharing threat actor information. So some entities we've cracked it precisely because the government has enabled the information sharing provisions. And I think we're just too restrictive, on it too restrictive.
So you said there's a lack of courage and ambition here. That's quite striking. Now, the bill also contains a provision requiring a 5-year review. And there are many pieces of legislation that haven't managed to be reviewed every 5 years. A previous witness suggested that perhaps the legislation actually should cease to exist if it's not reviewed after 5 years. Now, that's rather strong, but can you think of pieces of legislation that has been reviewed after 5 years? Well, in other countries? Well, in Australia, there has to be this overview that's done of the architecture of national security every 5 years. And there's a fair bit of flexibility for the individual who is responsible for that. The report is quite long, But usually there's a focus on one aspect in particular and an attempt to suggest improvements. So we're talking about pieces of legislation that aren't necessarily always visible to the public or to MPs because they're very, very complex. There can still be very significant consequences in terms of the protection of civilians and human rights. And given that the security environment is changing very quickly, and there are definitions in our legislation dating back decades, we need something, a tool, that would allow members of parliament to be able to act in a more timely and efficient manner.
We go now to Mr. McGregor for 6 minutes.
Thank you very much, Mr. Chair. Thank you to all three of you for joining us today. Professor Lupprecht, I want to revisit the issue of Part 4 being country agnostic, because I just wanted to present to you like a hypothetical situation. Of course, you know, the government of the day is guided by different political leanings, and it may view certain countries in different lights from its competitors in the House of Commons. I'm just wondering of a situation like in terms of listing a country, could there not be the potential of the government of the day's trade interests colliding with the country's national security interests, right? It's a very political decision to list a country. Does that not come with some pitfalls because that's essentially a political decision? There could be other things guiding a government's decision rather than purely the national security interests of Canada. Is that not a danger?
And we had exactly that situation very recently in terms of the reimposition of certain visa requirements on Mexican nationals to Canada, where there was a vigorous internal debate on precisely this sort of trade-off. And ultimately, this gives, if you want, the Minister of Foreign Affairs a stake on both sides, because the Minister of Foreign Affairs ultimately can make the trade argument, but the Minister of Foreign Affairs would also have the opportunity to list a country. And I think the listing regime is important because we've been very poor in the last 20 years of anticipating the evolution of the international security environment. And so in a case of a rapid degradation of the international security environment, where the government feels it might need to take fairly aggressive, rapid measures to protect Canadians and Canadian interests and Canadian institutions, this, I think, is an important tool that we will, not may, we will regret within your and my lifetime if it is not inserted into the bill.
In the interest of transparency, would we not also have an interest to know how maybe some of our closest friends and allies are influencing our political processes?
Yes, but they don't need to resort to covert, clandestine, coercive.
So that wouldn't be covered by a registry. The clandestine wouldn't be covered by the registry.
So our closest allies have plenty of legal mechanisms. I think, for me, the primary purpose of the registry is to lower the evidentiary threshold for investigations. Because in many cases, it is very difficult for security and criminal intelligence to reach the current threshold as defined in law in Canada. So with the registry, you are now giving the agencies a much lower threshold for the purpose of investigation. And that, I think, is the primary purpose.
Okay, thank you for that. I also want to recognize that you, from your comments, you see Bill C-70 as a bare minimum. And you did mention other statutes that you wish could have been acted. We're limited by what's before us. We can't go beyond the scope of the bill. But in the amendments to the CSIS Act, you did make mention of the fact that Section 16, a lot more could have been done with it. However, with what the government is proposing here in its amendment to Section 16, are you happy with that as an addition? Do you see any kind of improvements that we can make as a committee?
I think what I was hoping to signal is that there's nothing in this bill that you can really reasonably strip out of the bill. right? This is the minimum threshold. This is my that's the primary signal that I was hoping to send, and I appreciate that the government did have the guts to tackle Section 16 because that is inherently a long-standing controversy, and so just actually going there shows that there's actually some willingness to engage constructively on some key matters that might subsequently come up in other bills for further amendment.
Thank you. Ms. Regal, I'd like to turn to you, your expertise in criminal law. Of course, there are some significant amendments to the Security of Information Act with significant offenses and punishment. I think pretty much all of them involving life imprisonment. I know other offenses involving life imprisonment can be things like treason, mutiny, and things like that. Do you feel that the offenses or listed in these new amendments to the SOIA, do you think the punishments are in line with how, like do the punishments match how serious the offenses are, in your opinion?
Ce qu'il faut que vous compreniez, c'est qu'à la base, je suis
Well, I'm a defense lawyer first. So I take a humanist approach to my clients, and that's what guides me on a daily basis. But traditionally, life sentences have to do with violence or a risk to life, for example, or the risk to someone's personal integrity or terrorism. And when I read this bill, life, I think, is out of proportion with respect to the offenses that I see. There's 14 years in the criminal code, which is, I would say, fairly common for similar offenses.
Thank you.
Thank you, Ms. McGregor. So we'll start our second round now, and we will end this round with Mr. McGregor. And we will start our second round with Mr. Lloyd for 5 minutes, please. Thank you.
Thank you, Mr. Chair, and thank you to the witnesses. It's good to be back at committee. My wife and I welcomed our third child 3 weeks ago, so I've been taking a little bit of time. Thank you. Thanks to my colleagues for supporting me during that time. I'm going to talk about an issue that I don't think gets talked about enough. It's not really controversial, but in Section 31 of the bill, we have the 5-year mandatory parliamentary review. And in this legislation, differently from the NSICOP Act, there's also a report that needs to be given to Parliament within 1 year of that review. My concern is that we're currently almost 7 years, or we're 2 years overdue for the report on the NSICOP Act. And I'm concerned that if this legislation goes forward as is, that a future Parliament, and it might not be until 2 parliaments from now, given that there's a 4-year mandate if there's a majority government, it might not be until 2 parliaments from now that this critical legislation gets reviewed. And so, Dr. Luprecht, I was wondering if you had any suggestions or recommendations on perhaps should we shorten that review period from 5 years, and should we put additional language in there to ensure that this review takes precedence at committee rather than just being shuttled off whenever another piece of legislation or an important issue comes up, that just like the NSICOP Act review has been delayed. Thank you.
We live in a democracy, and it's ultimately up to the government of the day and our elected representatives to decide what the priorities are, how they're going to tackle them, and I think the Prime Minister has made that very clear also with intelligence and national security. There are, of course, other examples, the Proceeds of Crime, Money Laundering, Terrorism Financing Act, where the review is long overdue. I think, nonetheless, as a prof, my students, the first thing they always want to do is change legislation. I always tell them, changing legislation is probably the single hardest thing you could possibly think of. Think of a tax incentive, a policy, a regulation, whatever. Don't try to change legislation because you might spend a decade. Or you have to look for a political opportune moment to bring legislation such as this or C-51 or so. But nonetheless, it keeps the attention on the matter, where otherwise I think it would just drop off the radar and nobody will pay attention until we run into some sort of crisis. And if we think that the first and foremost obligation of the state is the safety and security of the citizens and of its political, economic, and societal institutions, then we need to have a mechanism to at least try to keep our eyes on the ball. And that's what I think these reviews do.
do you feel that the mechanism that currently exists in this bill, which is similar to other mechanisms we've seen, 5-year review, the language was slightly different. The language in this bill says must, but the language in previous legislation says that the committee is to. And I'm not sure that really gives any more clarity on whether or not committees will be mandated. It will be up to, as you said, whether or not the democratically elected officials at the time or the government at the time places a high priority on it. But clearly this is a high priority, and it's been something that's been neglected for far too long in this country. Would you recommend expediting those reviews to under 5 years? And also, would you recommend language that made it stronger and put the emphasis that this needs to take priority at maybe at the same level as legislation, which usually takes priority at committees?
So when the current government came to power, I think it had 85 reviews on the go at the same time. My concern is that we are too specific with the reviews, and it is generating too many reviews. And we would probably be better off with either a national security and intelligence review, or perhaps within the remit of this committee, a 5-year review on countering foreign interference, the mechanisms at our disposal. What did we do 5 years ago? What's working? What's not working? What could work better? Rather than trying to limit our swim lane so precisely to one institution and one agency and one particular act.
Thank you. And, some discussion that was on with the last panel was discussing whether this needs to be an independent officer of Parliament. Did you have any feedback on what's the pros and cons, and what would be your recommendation on that matter?
I've written on this publicly. I'm not a big fan of the proliferation of independent officers of Parliament, in part because I think reporting to the executive actually gets us, I think, more timely, more efficient, and in many cases more effective action. And I have a lot of faith in whatever executive is empowered to action. So I don't think an independent officer of Parliament will help with transparency. I do not believe that an independent officer of Parliament will help get things done and will help to get it done faster, better, or sort of more efficiently. So I think the bureaucrats are very well intentioned, or an independent outside judge, or some combination thereof, as Australia has done in the past with people who understand the system. I'm not sure you'll get something better out of an independent officer of Parliament, but I'm married, so I know I'm wrong all the time. So,
Thank you, Mr. Lloyd. We go now to Ms. Zaid. Ms. Zaid, go ahead, please. 5 minutes.
Thank you, Chair. Thanks to all the witnesses. My first question is for Madame Roulette. If I don't pronounce your name, please, apologies for that. This legislation takes a country-agnostic approach. Instead of creating a list of the so-called problematic countries it would apply to. So a list-based approach would be hard to update with changing and emerging threats, be open to political influence and considerations, and potentially stigmatize innocent members of the diaspora communities. So can you outline the risks of a list-based approach and why it is important to not unfairly stigmatize diaspora communities who are often at the greatest risk of the foreign interference and the threats?
Il est de ma connaissance du
Well, to my knowledge, the list that you're mentioning has no impact in terms of the Criminal Code or the Evidence Act. And that would make sense because the Criminal Code focuses on offenses in Canada and individuals, so not entities. You can't, under the Criminal Code, you can't prosecute an entity or a state. So, but I'm sorry in terms of the rest, that's rather outside my area.
Would you like to comment on that?
So you heard the witnesses before us. The concern that I hear from my friends and colleagues and in public isn't so much about stigmatization. It is about foreign repression in their lives by hostile state actors. And I have written publicly about my concern that all this talk about stigmatization risks playing into the narrative that precisely our hostile state actors are using in order to impede our ability to pass precisely the legislation that will keep our diaspora communities not only safe from foreign repression, but will protect the freedom of expression in this country.
My next question is again for Madame Roulet. This legislation adds the word intimidation in Section 20 of the Security of Information Act, and I quote, "Every person commits an offense who, at the direction of, for the benefit, or in association with a foreign entity or a terrorist groups, induces or attempts to induce by intimidation, threat, or violence any person to do anything or cause anything to be done." End quote. I agree with the spirit here, but do you feel there needs to be clarity on just what constitutes intimidation in this context?
Certainement, les menaces.
Certainly, threats and violence are defined in criminal law. Intimidation isn't. So Parliament needs to define it. If it doesn't, then you open the door to courts having to define it themselves. And eventually perhaps going as high as the Supreme Court. So yes, it would be preferable to define this concept clearly. That is to say what Parliament considers intimidation to be.
Thank you. My next question is for Mr. Neiman. Can you please explain how the threat sharing with UK companies has worked out, and are there any lessons to be learned from that?
Mr. Chair, thank you for the question. I'm not intimately familiar with how UK operationalizes the threat intelligence. However, at the highest level, I do understand that amongst the Five Eyes nations, Canada is an outlier in terms of the lack of authorities that our domestic security agency has to share threat intelligence with the business community. We just spent a week in the United Kingdom last month where we met with the UK's domestic security agency, MI5, and they have a special body that is designed purely for the purpose of collaboration with the private sector. And they had told us quite specifically that they have the authorities that CSIS is now seeking through Clause 34. And they tell us that those authorities are working effectively, and it's allowed them to build very robust partnerships that has been starting to build increased resiliency across the economy. We've also had an opportunity to recently travel to Washington, D.C. to meet with the Office of the Private Sector, the Federal Bureau of Investigation, and they also have similar authorities. And there's the model that we looked at in the United States that has worked quite effectively is something called the Domestic Security Alliance Council, which is a joint partnership between 700 strategically important U.S. companies, the Department of Homeland Security, and the FBI. And through two-way exchange of information between the United States government and the U.S. corporations, they're able to advance the United States mission of protecting that country's national and economic security, while at the same time helping U.S. corporations better protect their employees, their customers, and the communities in they operate. By participating in this organization, both the public and private sector gain access to senior leaders within those two sectors. The private sector gains tailored access to threat intelligence specific to their sector, and then the public and private sectors also gain access to a very large and robust network of senior security executives who can work together jointly to solve security issues, to share best practices. And we believe that Canada is really well positioned, CSIS in particular, Department of Public Safety, and the business community, to establish a similar body to DSAC to operationalize the authorities contained within Clause 34. So if we're looking for examples to operationalize what's contemplated in the legislation, I think the FBI and the DHS's Domestic Security Alliance Council would be a model that we should look for.
Madam Said, there's a competitive issue here, right, in terms of prosperity, because why would you invest in Canada if you know you can get better threat intelligence in the United States, in the United Kingdom, or in Australia? So,
thank you. On y va maintenant, Monsieur.
Mr. Villemur, you have the floor for 2.5 minutes. Thank you, Chair. Ms. Rowe. My colleague made a comment here that made me think twice. Now, there was a great linguist who said to translate is to betray. So in section 2, there's a reference to review by committees.
Within 1 year after the review is undertaken, must be undertaken. The must be undertaken.
So there's the must and is in French. They don't have the same force, do they? Do you see this kind of thing happening with translations in legislation? Well, in criminal law, oftentimes the versions aren't identical. There's often a difference between the French and English versions. Under the Charter, you have to use the version that is most favorable for the accused. Under the Canadian Charter I'm talking about. Well, in a bill like this one in C70, I have found 4 places like this where there are semantic differences between the French and English version. Should I be worried? Well, my simple answer would be yes. Well then, I guess we'll have to take a closer look at this. I found 4. Is there anything you'd like to add to your testimony with my remaining seconds? Well, very quickly. I think I'm going to take my best shot at the answer to the question about intimidation. So in section 483 of the Criminal Code, there are intimidation techniques that are described. Now, I don't know how that would apply to the question that I was asked earlier. And I'm going to say that in the Evidence Act, under 37.1, you're removing a section. It says that the accused must be found guilty, and it's only at the very end of the trial that a complaint can be laid. But there was in previous legislation, and there is elsewhere, an interim appeal. So, and I don't see that in this one. Well, I am worried about some of the things you're saying that aren't in here because we have to study this so quickly. So perhaps I'll just, I really just want to take 5 seconds to express my concern.
Mr. McGregor, please bring us home. 2 minutes and a half.
Thank you, Mr. Chair. Ms. Rayo, I want to talk to you about the criminal code amendments in this bill because in this bill, it largely follows the theme of combating foreign interference. And then you get to the section about the criminal code, and it just seems to have been thrown in there. And it doesn't seem to flow with the rest of the bill. I was trying to follow your remarks about the sections that you found problematic and too broad. But just in the time that I have left, where do you think we as a committee should focus if we're considering amendments to fix the problems that you addressed? Is it the sections where it's clarifying for greater certainty that, provides an out for someone that they're not committing an offense if they're involved in advocacy, protest, or dissent? Is that probably the best focus for us? I'd just like to hear your thoughts.
That's one of the best focus, yes, especially on the last 3 lines of that paragraph. 52.1 needs, in my humble opinion, to be looked over again by the committee. It's one with the adding section of the criminal code is one more problematic. It's too large. It doesn't focus, I think, on what the committee wants to focus on. And it would create a section where a lot of infraction would be thrown in, disregarding the purpose of that bill.
Okay.
So yes, and of course, section 52.3 also, if the committee wants the federal government to stay in control of those articles, 52.3 needs to be changed with adding
The
Attorney General of Canada. Yes,
Okay.
because otherwise you would lose all control.
Okay.
Province would get control of those.
Okay, appreciate that. I think I only have a few seconds left, so I'll just take that to thank all three of you for helping guide us through this study. Appreciate it.
Thank you, Mr. McGregor, and thank you to all of our witnesses for appearing today, and especially on short notice. It's most helpful, and we will, with that, we will adjourn. Thank you all. And to the committee, see you tomorrow morning, 8:15.